Hi guys, I'm Mateusz Korus from the law firm Korus Legal. We operate in Poland, Austria and Germany, and one of our expertise areas is asset protection. Especially we help families, entrepreneur families, setting up family foundations in Poland, but also abroad. And today, a very interesting topic, the Liechtenstein Foundation, one of the probably most prominent, best marketing foundations in the world. And we will try to demystify the foundation in Liechtenstein. Today, a very special guest, a fine lawyer from Liechtenstein, Philipp Konzett from the law firm Nueber Konzett Rechtsanwälte, one of the finest addresses in Liechtenstein for help setting up a family foundation and running a foundation in Liechtenstein. Great having you here on the channel, Philip.
Hi, Matthias. Thank you for having me.
Okay, let's dive in. A very interesting topic. And Philip, could you make just a short introduction and say something about you and your law firm?
Well, thank you, Matthias. Of course, I'd love to. We are a Liechtenstein law firm, newly established, but we've been active in the market quite a long time already. We are specialized in foundation law and trust law, and we advise our clients when it comes to setting up a foundation, how to set up a foundation, what would be the best structure and governance system of the foundation. And we also help them if an existing foundation doesn't work in the way it should work. We help them with disputes, we help them with arbitration in a foundation context, and in succession planning and estate planning, asset protection in general.
Okay, so why the Liechtenstein Foundation is so popular? Why so many rich people are setting up foundations in Liechtenstein?
I think the reason for setting up or for choosing Liechtenstein as a jurisdiction where you set up your foundation, there are a lot of reasons. I'd like to start with the country. The country itself is really stable, is financially extremely sound. It is one of the very few countries without any financial debts or national debts, and we hear many founders who say this is one of the key factors, that they just trust in the jurisdiction, they trust in taxation staying low and remaining at an agreeable level. Liechtenstein is also part of the Swiss franc area, so Swiss franc is a very stable currency, is the official currency in Liechtenstein, but unlike Switzerland, Liechtenstein is a member of the European Economic Area. So you have access to Liechtenstein from both sides, from the Swiss side and from the European side. And based on the principles of free movement of capital and establishment, everyone from the EU is free to come to Liechtenstein and set up their foundation here and set up their business here, even if they want, and moving capital to Liechtenstein, to this very stable country. This is the political side, or the political reasons why many rich people choose Liechtenstein as their foundation hub. Others lie deep-rooted in the Liechtenstein Foundation law. When they set up the foundation law almost 100 years ago, they had the idea to come up with a very liberal, very flexible foundation law that gives the founders the opportunities to draft and structure their foundations in a way that fits them best. Other foundation jurisdictions that I know of, like Austria, for example, they've provided far stricter boundaries to what the founder can do with their foundation, what they need to accept from the law and what is provided by law and what's obligatory by law. And Liechtenstein has only very few rules that are obligatory and many other rules that the founder can adjust and can make work in a way that he or she wants when they set up the foundation. So I think the core principles, the core reasons why people come here, it's very stable. It is known to be a very stable jurisdiction and country. It has a very liberal, tested foundation law, almost 100 years old. So it's a proven jurisdiction for asset protection and estate planning. And then you have a very good and flexible foundation law that actually has served as a model for many other foundation laws all over the world. But it's always better to go to the original than to just choose the copy, right?
Exactly. Especially the very long tradition, it makes so predictable so many things, like in kind of, for example, some disputes, and then you have this casework that actually is providing you guidance how your dispute may end up. So I think this is advantage that of jurisdiction with a stable and very, very long-lasting law. One of the first questions probably someone might ask is, if I will set up a foundation in Liechtenstein, do I really need to live in Liechtenstein or to move my taxation into Liechtenstein?
No, you don't have to. Actually, it is quite difficult to set up residence in Liechtenstein, and to get a residence permit in Liechtenstein, it's almost impossible. But you as a founder and the beneficiaries, they do not have to move to Liechtenstein. Everyone is free to set up their foundation in Liechtenstein, even if they remain in Poland, remain in Austria, Germany. Many of these rich families are what I call global families, right? They're distributed all around the globe. One of your child may be studying in the US, another one may live in Switzerland, and you remain in Poland, for example. That is not a problem for Liechtenstein foundations and foundation service providers. You don't have to move here. Actually, Liechtenstein forms part of the agreement on the automatic exchange of information, tax-wise. So it is very easy for trust service providers in Liechtenstein to set up foundations and to operate them in a manner that is compliant with your local law wherever you are, right? Whether you are in France or in England or in Poland or anywhere else. This allows you to have this financial cash box set up in Liechtenstein that is stable and that is there to serve your family throughout the generations without actually restricting you and your family members, your children, to move around and to set up residence wherever you want to wish to.
Okay, so you have a flexible environment. It's very interesting. Could you dive in? Like, what are the differences, for example, with Poland, Austria, Germany? So can you give any examples for the flexibility, for the solutions that you can provide in Liechtenstein that you cannot set up in other countries?
Yes, I'd love to. For example, with Austrian foundation law, which is also considered a quite liberal foundation law, but still the founder is not allowed to sit on the foundation board of an Austrian foundation, and there is a lot of review that needs to be done for the foundation board members and in counting wise and stuff like that. On the other hand, in Liechtenstein, the founder is quite free to choose whether he wants to be a part of the foundation board or not, whether he wants to be a beneficiary or not, under which circumstances he wants to exercise founder rights or be able to exercise founder rights. For example, changing and amending the foundation statutes and the bylaws, but also making a resolution on the dissolution of the foundation, so getting rid of the foundation again. Liechtenstein foundation law provides for all these opportunities. It is quite flexible in this sense that the founder can set up a foundation governance system that he likes. For example, he is free to make the foundation subject to a public supervision from the public foundation supervisory authority, but he is also free to renounce it, say, I don't want to have a public supervision on my foundation. I want to organize my foundation governance myself. I want to set up additional bodies in a foundation, like a protector, who will keep an eye on the foundation and who will make sure that the foundation board is doing what they're intended to do. And then there is also a lot of flexibility when it comes to amendments to the foundation statutes, in case the founder dies or passes away. It is a bit restricted as much as it needs to be restricted from legal certainty perspective. But still, there is a lot of things that you can do and that the founder can actually trust that his foundation will not be a petrified thing living in times long gone, but the foundation can actually evolve with the time passing, and this obviously gives a lot of comfort to founders who choose to come to Liechtenstein.
Okay. So one issue is a very stable, good environment for setting up a foundation. So it's very important for protection. Like people normally think it's just about money, but sometimes it's more a topic of security and then about the money. So let's talk about the money, because it's also like an issue, the taxation of the foundation in Liechtenstein. So what's the effective taxation of any benefits that are distributed to the beneficiaries? And what's the taxation of profits that stay in the foundation without being distributed?
Well, again, you can clearly see that Liechtenstein has a very, very liberal approach to that, and it gives you the choice how you want to set up the foundation. The ordinary taxation is 12.5% on your income, which I think is a quite competitively low rate for most of the countries. Even more so if you consider that there are, accounting-wise, the possibility to deduct a certain percentage for your equity. But that is the ordinary taxation. And when I'm speaking about having the choice, Liechtenstein Foundation law and Liechtenstein tax law also give you the choice to choose for a flat rate tax. The flat rate tax is 1,800 Swiss francs per year, covering everything that the Liechtenstein Foundation makes in profit every year. I have to say this is only the Liechtenstein side of things. Obviously, the local tax authority, wherever the founder is located or wherever the beneficiaries is located, might apply additional taxes on that. The minimum taxation of 1,800 Swiss francs is usually used for tax transparent structures. In certain cases, it may make sense to have a tax transparent foundation that does not have any negative tax consequences in your country. And the ordinary taxation of 12.5% of the income is usually used for intransparent tax foundations that are tax-wise intransparent. When it comes to distributions, again, Liechtenstein is a financially extremely sound and stable country, so they don't really need a lot of income, so they decided to make distributions tax-free. You can receive distributions tax-free from a Liechtenstein perspective. Again, your local tax authority might want to apply and make it subject to an additional, dividend tax or capital income tax. That would be something that we need to take a closer look at if a founder comes and sets up a foundation. But from a Liechtenstein perspective, the tax burden is really, really low. And the idea behind it is that it is going to be taxed in your country and not in Liechtenstein. So Liechtenstein is out of the game, more or less.
Yes, but still, I think this is very competitive, especially with this lump sum scheme that is actually very popular nowadays. It's not only Liechtenstein that provides this, even Poland is providing this, like Italy is providing this, Georgia is providing this. There are several jurisdictions in I would say, close to Europe and in Europe that are going this direction. But then you can combine this with the stability of having a foundation in Liechtenstein. That's very good. How does the distribution work actually? It's like for someone who just thinks about setting up a foundation. So you set up there a foundation, but how do you like get the assets there, and how do you then take the money out? Like
that is a difficult question, or a complex question. Let's put it this way. So what the founder does when he or she sets up a foundation is they define and determine the purpose of the foundation. The purpose of the foundation is what are the assets meant to do, and to whose benefit are the assets out there. So, for example, I pay in, let's say, 10 million euros into my foundation as a founder. Then I have to define for whose benefit will these 10 millions be there and be managed in Liechtenstein, and under which circumstances will my beneficiaries or the beneficiaries of the foundation receive distributions. And then there are two options that I can have, or that I have as a founder. I can say, for example, my beneficiaries shall receive a fixed amount of money at time. So, for example, every year at their birthday, they receive a distribution of 10,000 euros or any other amount that you define. And in this case, they will receive it automatically upon a resolution of the Board of Foundation. they could also go to court and sue the Border Foundation and say, you didn't pay me my 10,000 euros for my birthday. I want to make you do it. So this is the first option. The second option, and that it is far more popular, is to have a discretionary foundation, which means that you, as a founder, you pay in the money, you define the purpose, you say the purpose is to benefit my family and everyone that comes after me, my heirs, my children and my grandchildren and everyone after them. But I will give the foundation board the discretion to determine in which time and which amount will be distributed from the foundation. In this sense, if this is the case, then the foundation board has to come together. They have to discuss it and then form a resolution about the distribution of a certain amount. And usually in practice, this will be done upon a request of the beneficiary. So the beneficiary comes to the foundation council and says, look, I need money. For example, I just married, I want to buy a house. And the foundation purpose says the money in the foundation is there to serve the beneficiaries, to equip them with everything they need for their life. So the foundation council receives the request, looks at the foundation purpose, compares it and says, yes, this fits, right? It works. It is the intended purpose of the foundation to pay out the money to buy this house, to start a family. Then they will resolve it and then make the payment and the distribution to the beneficiary.
Okay, I think that's very comfortable because you have also an option. Okay, I don't want to be as active in the foundation. I want to have someone that I trust or people that are there picked up through a certain process and they make the decision. But still, can I make, for example, as a founder, may I set up a policy for example, asset allocation? So I make a bigger framework. So how I want the money to be, for example, distributed in terms of investment, and then some directions how do I want to give the money to my closest family. Is it possible to set up such frameworks within the foundation?
Absolutely, it is. Actually, that is what most founders do. They provide detailed rules on how these assets shall be first invested and managed. For example, I've seen foundations where the founder provided that foundation assets have to be the underlying company needs to be managed with certain principles, having in mind certain principles like looking after the employees too and the environment and stuff like that. So you have the management side, which the founder can define, and you have also the distribution side. You can say one of my beneficiaries shall receive 20% ultimately, another one shall receive 5% or 10% or any other percentage that you want. You can also provide any other form of guidance to the board of foundation. For example, I do not want them to receive money if they are addicted to gambling or addicted to alcohol or drugs. But I want the Foundation Council to consider situations where they are in need, for example, or emergency situation, and especially consider emergency situations, for example. So what is quite common that a founder provides the Foundation Council shall pay particular attention to a beneficiary who is in trouble without his fault. For example, due to insolvency of his own company, of his own business, that he did not cause, or that where he is subject to floods or to other environmental catastrophes, and the foundation board shall pay a particular attention to that. Okay. So it is absolutely possible to do that and to give this guidance to the Foundation Council, basically. Every Foundation Council will be happy to accept this guidance because it makes their lives easier.
Of course. It's a very big problem in Poland, like having those trusted people on the board. And the typical question, one of the first questions, is how many people do I need to set up a foundation in terms of who will I put in the management board? And then, for example, there's an option in Poland for supervisory board, and you have additional people. And then sometimes it's not easy to find 5, 6 trusted people who will be there. So what's the solution in Liechtenstein?
So the law provides only one number, and that is 2. The law says you have to have at least 2 foundation board members, and that's the minimum. Obviously, the founder is free to increase this number and say, I want to have 4, for example, or 10, or I want to set up an advisory board with my family members being on the advisory board. But the minimum amount for the foundation board itself, for the management of the foundation, is 2. And what we see quite often is that you choose a Liechtenstein trustee, a professional trustee, which is obligatory to have it, him or her on board. They will make sure that the know your customers, the compliance, and the reporting is done correctly according to Liechtenstein law. And usually the second foundation board member is then the trusted lawyer of the founder, which could also be a foreign lawyer. For example, if you come with a client, or if anyone comes with their lawyer to us and says, I want to have my lawyer on board because he's been the family lawyer for 20 years, and he knows the business well, and he knows me well, and here's the family. And he was also the lawyer in my last divorce, for example. And he's really the one I trust most.
Then he will do a good job there.
He did a good job there. I still got money to put in. So you can have everything that you want, basically. It makes sense to also include, but that's always a decision the founder has to make, to include a Liechtenstein lawyer also, not only a Liechtenstein trustee, but also a Liechtenstein lawyer. The reason for it is that it has become more and more a legal issue with all this international cooperation, to make sure that there is someone who has good knowledge of the law, and it's not only a trustee who is very good in reporting and doing compliance and doing the management stuff, but who is also an expert in Liechtenstein Foundation law. So that is what we advise to our clients. Obviously, they are not obliged to do it. It is just an offer. But what they do in most cases is to involve their local advisor, their local lawyer, their friend even, and they can have any kind of role. We've seen also quite often that they say, I want to have my foundation managed by Liechtenstein professionals, Liechtenstein trustee. They will provide the necessary amount of board members, but I will include my friend or myself or my lawyer as a protector or as an additional body in the foundation. And I will give this protector special rights, like a right to remove the Liechtenstein trustee without any reason, to fire them immediately if they don't do what is right for the foundation, or to make the selection within the circle of beneficiaries to say, okay, now this beneficiary shall receive this amount of money, or that beneficiary shall receive that amount of money. So you can remove these competences from the board of foundation and give it to someone that you actually trust. The only thing that you as a founder have to decide in the very beginning, and there is no way around it, is the circle of people that can receive distributions from the foundation. It is really, really difficult to add other people later on.
Okay, there's another question coming here about the beneficiaries. Okay, so let's say I'm the founder, I put some money, some assets in Liechtenstein, and then I die. And what happens then? How the next generations can be protected? What are the rules?
Well, that is actually the core reason why most people set up a foundation, is to plan their succession and to plan who will receive their fortune after they pass away. And this is what I mean with defining the circle of beneficiaries, the giving the names of the beneficiaries. But you can also give a description of who will be the beneficiaries. In family foundations, founders will usually say, I'm the main beneficiary, I and my wife together, for example. And if we die, or if one of us dies, our children will succeed. They will come after us and they will receive a certain share of the foundation. And if they die, their children will get this. And you can go on for eternity like that if you want to. So the Liechtenstein Foundation does not have a rule against perpetuities. You know that from English trust law, for example. So they could theoretically live on forever and keep on forever making distributions to your children, to their children, to their children, and so on and so forth, and to anyone that you actually define as a founder. in family foundations, they are not restricted to the family. They could also include special friends or other people that are very important for them. And also, of course, charitable foundations or charitable organizations if they want. So if they do not want, so they do not have to.
What about disputes? It's a very hot topic, especially in Poland, as we have some big business that is organized through two Liechtenstein foundations, and they have some discrepancies in opinions. And so what will happen, for example, if I as a founder have some legal matters where I disagree, for example, with my children, but I'm trying to put them in the board, to give them the power in the foundation. So what are the solutions in Liechtenstein? How does it work then?
Well, I think it is like with everywhere. If there are humans involved, then ultimately there will be dispute sooner or later. And the important question is how to resolve a dispute, right? And Liechtenstein Foundation is, again, very, very flexible and liberal in this perspective. You as a founder, you can define, if you want, a clear dispute resolution mechanism. So, for example, you can provide that a dispute within the family must be decided by a family advisory board or must be brought before a special designated members of the family who will then have the task to mediate between the parties and to try to find a solution before going to court. Because what we see quite often is that the moment you go to court, the family relations are done, right? It is very hard to come back after that, after fighting in front of a court. So most founders actually acknowledge that and they understand that. So they set up this dispute solution mechanism that kicks in before it is too late in an attempt to keep them away from the court and solve family disputes within the family. Obviously, that is not mandatory. You don't have to. As a founder, you can also say you're free to go to court. You're able to set up arbitration clauses in a foundation, so they are not, your family disputes are not being out there public in a public court hearing where every journalist can show up. If you do not want to have this, you can include an arbitration clause in your foundation, and then everything will be resolved in an arbitration by an arbitral tribunal, which is then secret again. So especially for very rich people or people that are public figures, this is a very important factor to be able to keep the dispute, a family dispute that can arise in any family, and in the best families there will be dispute, to keep it out of the public eye and to keep it within an arbitration. When it comes to Liechtenstein courts, they're very good. They're known to be very, very fast. So the country is quite small, and if they know something, then it's foundation law. So they are very good in resolving foundation disputes. Again, as I told you, if you go to the public court, the hearing will be public. So while we hardly see anyone else in the courtroom except for the parties, theoretically there is the possibility for anyone to show up and to make notes and then publish it if you want, if you're a public figure. Arbitration is another kind, especially in smaller disputes or disputes with smaller amounts in question. Arbitration can also be quite expensive. So this is something that we will talk a lot about with our founders and clients, what they want to have, how they want to define and manage basically the dispute, even if they're dead, right? So if they die, this mechanism will kick in, even if they are dead, and it is the third or fourth generation.
Yes, of course. Okay. In terms of providing assets into the foundation, probably the most typical solution is that you have some companies in other states, for example, I don't know, in Austria, in Germany, in Poland, and then you put the shares of those companies into foundations that a good lawyer as you helps to establish in Liechtenstein. But can you also put the assets in another way? For example, can you put some real estate directly into the foundation?
Yes, you can. From a Liechtenstein perspective, the Liechtenstein Foundation is a legal subject that is able to hold any kind of asset in its own name. So you can put in bankable assets like your portfolio, your shares, but also your shares in your holding company or your business, so to speak. Quite often, actually, foundations also hold real estate and property directly. This is mostly the case if there is a very special real estate that has a history with the family. So with noble families, for example, they have their castle and they put it in a foundation because the castle shall pass on to the firstborn and it shall not be divided amongst the heirs with forced heirship and stuff like that. So they put it in a foundation. But we also have real estate investors that put their real estate into foundations just as a means of asset protection and in order to protect them from being diluted, the shareholdings being diluted throughout the generations. We also once had a foundation that was meant to hold immaterial rights. It was a very famous singer actually, and she wanted to put in her rights of the profits that she will receive every quarter, and she wanted to put it in. And of course, that is no problem. The foundation will then hold her rights and receive her dividends payments for her artwork.
Okay. Can you combine the Liechtenstein Foundation with foundations in other countries, like in Poland or in Germany? So I have some, like for example, some previous foundations having back, for example, in the country that I started my business and then establish, for example, as a kind of a holding, the Liechtenstein Foundation in Liechtenstein. Is it possible?
Yes. The lawyer that I am, I have to be quite strict on that. You cannot combine it in a sense that they merge or demerge together because they're legal persons on their own. But you can make them interact and you can make them coordinate and cooperate with each other. You can, for example, have the Polish or the Liechtenstein Mother Foundation, which will then feed other sub-foundation. What we have done quite a lot in recent years is establishing so-called sub-foundations, or what we call sub-foundations, in an attempt to, for example, get assets out of an Austrian foundation. The Austrian foundation establishes a sub-foundation in Liechtenstein, makes it a beneficiary, pays its assets into the sub-foundation, and then you will dissolve the Austrian foundation. So this is what we've done in the past. But I take your question in another way. If there is a continuous cooperation and interaction between the foundations, and of course that is possible. In fact, and this is just, it's quite rare, but theoretically possible, your foundation could even be a board member of the Liechtenstein Foundation. So the Polish foundation could act directly as a board member of the Liechtenstein Foundation. That would be the ultimate cooperation, I guess.
Yeah, of course. But this is very flexible environment where you can really make tailor-made solutions. that's your brand of your law firm. I love it.
Thank you for the shout out.
It's really great, especially in the field that you operate. I love it. Okay, so one last question about the money. And I will not ask about your rates. I'll ask you, what's the minimum amount? I think they are reasonable for the kind of service that you provide. I think this is like having a good lawyer. It's always advantageous, especially when the lawyer knows what he does and he knows like have a kind of mission and a really deep knowledge that you obviously have. But like there are some people thinking about like, I want now I actually established some businesses in one country, on different countries. I have now some money, but when does it make sense? So what kind of like what amount of assets do I have in order, to go to Liechtenstein to set up the foundation? It costs, of course, and what is the minimal amount of capital that makes sense?
Okay, that is a really, really good question. I get this question a lot, right? And as good as it is, as difficult the answer to this question is. I give you several answers, okay? It will depend on your individual case whether a foundation makes sense in your particular situation. Usually, if you put in just bankable assets or working capital like your own company, then I would say, this is just an estimation from my side, I would say the foundation asset should be around maybe 8, 9, 10 million euros. It starts making sense, all this effort that you put in setting up the foundation, and also the benefits that you want to achieve, and also the pitfalls that you want to avoid through succession, to put it in a foundation if the amount of their foundation assets are at least probably 9, 10 million euros. In certain circumstances, it may also make sense to have lower foundation assets. For example, when it comes to startups, we see it sometimes that startups put in, or startup founders put in their startup in a foundation in a time when the startup is still not very valuable. And they hope that their startup will go through the roof and will be extremely valuable. And they want to get it out of their country before there is any value, because you have, for example, a gift tax, or you have any other tax that would apply if you move it once it's valuable, and put it in a foundation once it's valuable. They want to be one step ahead of the game and say, I trust in my startup, but it's not that valuable yet, right? So I put it in, I accept a very low gift tax, and then I can continue working on the startup. That's not a problem. And I'm certain that I will receive the economic benefit of the startup because I'm a beneficiary of the foundation, but it is held by a Liechtenstein legal entity, and therefore there will be no exit tax, there will be no taxation on that. So in these cases, the startup might only be worth a couple of €100,000, for example, and still it would make sense for them to set up a foundation. So there are tantamount cases where you might come to the conclusion that a foundation makes sense in your case, even though you do not have 10 million euros. I always say the most important thing is to come and ask and to have a discussion on it. It doesn't cost too much, and you will have the peace of mind whether it makes sense or not. And then you can decide yourself whether you want to have it or not.
Especially as it's a very important, one of the most important decisions of your life, if you want, to set up some structures for your asset protection. So I think it's always to know what your options are. So
exactly.
Thank you, Philip, for this interview. It was very, very, very interesting, and I hope to see you soon.
Thank you, Matthias, for having me, and it was a pleasure.
See you. Bye-bye.
See you. Bye.